Hi, I'm Anna Denton-Jones, and in this week 4 of Knowledge November, we are talking about my practical tips in relation to making reasonable adjustments for those with disabilities. I'm going to say, in respect of anything that crosses my desk, communication is the key. This area it applies to just as much as any other. What I quite often will see is employers who've had a really good stab at making reasonable adjustments when the person's been first diagnosed with something, or when the employee has started work with them and they've been made aware of a health condition. But quite often that was a long time ago, so maybe 3 years ago, 5 years ago, 10 years ago, and the company has changed around, or the organisation has merged, or the line manager has changed. So that knowledge quite often around the reasonable adjustments has not cascaded through the organisation. There's a case called Ishola and Transport for London that illustrates this particular issue. So the individual concerned had mental health issues, suffered from migraines and stress, and there were various reasonable adjustments in place, including wearing a special headset, doing specific duties, so he was either allocated to correspondence or making telephone calls. He wasn't having to mix them around. He had a change in shift pattern. He had a particular desk rather than having to hot desk, and he had unrestricted breaks. So the clash point comes where he's got a new manager and he's been away from his desk for 45 minutes. On that particular day, he had been unwell. He'd been to the bathroom and then to the pharmacy, but he'd obviously been gone a long time. And new manager doesn't know where he is or what he's doing, and accosts him when he comes back into the workplace, and has perhaps been slightly more aggressive than he would have been if he'd known that there was this reasonable adjustment in place. So there's been this breakdown of communications. Surprise, surprise, we end up with the employee off on the sick and raising a grievance and bringing claims, including for race discrimination as well as disability. Most of those claims were not upheld, you'll be glad to hear, but specifically on the issue of reasonable adjustments, which is relevant to us today, the tribunal found that the organisation had failed to put in place a system for that knowledge to be cascaded through the organisation, so that future managers or other people understood what reasonable adjustments had been made. So in any organisation, you are going to have to think about who needs to know. So that might be the IT department to make certain adjustments. It might be learning and development. Other people that individual is going to come across in the course of doing their duties that might need to make adjustments for him, so as well as the line manager. So it's no good HR knowing about this, the line manager needs to know as well. Now, GDPR, you know me, I love a bit of GDPR, data protection. What we're cascading is not all the details about the person's medical position, it is the reasonable adjustments that we've agreed to make. So no one needs to know why we've agreed to make them, they just need to know that there is this description in place. Now you might get employees, myself, I would be quite open about my situation, so all my colleagues would know. I wouldn't have an issue with that, but lots of people don't want to share the ins and the outs of things with their colleagues. So you do need to be really careful about unnecessarily circulating information about people's sensitive medical positions. Hopefully that's been useful to you. If you've got any questions, please let me know. It's adenton@refreshinglawltd.co.uk. Thanks.